Start. This is an appeal by special leave. Stop. It arises from execution case number 19 of 1961 in the court of the first additional civil judge, Varanasi. Stop. Therein, certain properties belonging to the judgment debtor were sold. Stop. The appellant moved the executing court under Order 21, Rule 90, CPC to set aside the sale. Stop. His application was dismissed on the ground that he was not an interested party. Aggrieved by that order, he went up in appeal to the High Court of Allahabad. Stop. The High Court reversed the finding of the lower court that the appellant was not an interested party, but at the same time dismissed the appeal on the ground that as the appellant had not complied with the requirements of Rule 90, Order 21, CPC, as amended by the Allahabad High Court, his application was not maintainable. Stop para. The amended proviso with which we are concerned in this appeal reads thus: para. Provided that no application to set aside a sale shall be entertained upon any ground which could have been taken by the applicant on or before the date on which the sale proclamation was drawn up, and unless the applicant deposits such amount not exceeding 12.5% of the sum realized by the sale or furnishes such security as the court may, in its discretion, fix, except when the court, for reasons to be recorded, dispense with the requirements of this clause, para. Provided that no sale shall be set aside on the ground of irregularity or fraud unless upon the facts proved the court is satisfied that the applicant has sustained substantial injury by reason of such irregularity or fraud. Stop para. Clause (b) of the proviso was added on 7/6/1962. Stop. The application with which we are concerned in this case was made on 3/1/1962. Stop. The applicant did not give security as provided in the newly amended clause, nor did the court call upon him to do so. Stop. Before the executing court, all the parties proceeded on the basis that the application was regularly made. The objection as to the maintainability of the application appears to have been taken for the first time in the High Court. Stop para. Before the High Court, it was contended on behalf of the appellant, and that contention was repeated in this court, that clause B of the proviso did not govern the present proceedings, as the application in question had been filed several months before that clause was added to the proviso. Stop. It is the contention of the appellant that the expression stop entertain clause found in the proviso refers to the initiation of the proceedings and not to the stage when the court takes up, the application for consideration. Stop. This contention was rejected by the High Court, relying on the decision of that court in Sridhar versus Jagat Lal Sharma, AIR 1987, Allahabad 547. Stop. The same view had been taken by the said High Court in Roopchand versus Om Prakash Gupta, AIR 1907, Allahabad 543, and Haji Karim Baksh and Sons versus Firm Ijatullah and Sons, and again in Mahavir Prasad versus Jatashankar. Stop.